Those lies materially impaired the investigation of Russia interference, according to your report. Other than the individuals who pled guilty to crimes based on their lying to you and your team, did other witnesses lie to you?
I think there are probably a spectrum of witnesses in terms of those who are not telling the full truth, and those are outright liars.
Thank you very much. Outright liars. It is fair to say then that there were limits on what evidence was available to your investigation of both Russia election interference and obstruction of justice.
That's true, and it's usually the case.
And that lies by Trump campaign officials and administration officials impeded your investigation.
I would generally agree with that.
Thank you so much, Director Mueller. You will be hearing more from me in the next hearing, so I yield the balance of my time to Mr. Correa. Thank you.
Mr. Mueller, first of all, let me welcome you. Thank you for your service to our country. You're a hero, Vietnam War vet, wounded war vet. We won't forget your service to our country.
Thank you, sir.
I may begin. Because of time limits, we have gone in depth on only 5 possible episodes of obstruction. There's so much more. And I want to focus on another section of obstruction, which is the President's conduct concerning Michael Flynn, the President's National Security Advisor. In early 2017, the White House counsel and the President were informed that Mr. Flynn had lied to government authorities about his communications with the Russian ambassador during the Trump campaign and transition. Is this correct?
Correct.
If a hostile nation knows that a U.S. official has lied publicly, that can be used to blackmail that government official, correct?
I'm not going to speak to that. I don't disagree with it necessarily, but I'm not going to speak to any more to that issue.
Thank you very much, sir. Flynn resigned on February 13, 2016. And the very next day, when the President was having lunch with New Jersey Governor Chris Christie, did the President say, open quotes, "Now that we fired Flynn, the Russia thing is over," close quote. Is that correct?
Correct.
And is it true that Christie responded by saying, open quotes, "No way, and this Russia thing is far from over," close quote?
That's the way we have it in the report.
Thank you. And after President met with Christie, later that same day, the President arranged to meet with then FBI Director James Comey, alone in the Oval Office, correct?
Correct, particularly if you have the citation to the report.
Page 3940, Volume 2.
Thank you very much.
And according to Comey, the President told him, "I hope," open quote, "I hope you can see your way to letting this thing go, to letting Flynn go. He's a good guy, and I hope you can let it go," close quote. Page 40, Volume 2.
Accurate.
What did Comey understand the President to be asking?
I'm not going to get into what was in Mr. Comey's mind.
Comey understood this to be a direction because of the President's position and the circumstances of the one-to-one meeting. Page 40, Volume 2.
Well, I understand it's in the report, and I support it as being in the report.
Thank you, sir. Even though the President publicly denied telling Comey to drop the investigation, you found, open quote, substantial evidence corroborating Comey's account over the President's. Is this correct?
That's correct.
The President fired Comey on May 9th. Is that correct, sir?
I believe that's the accurate date.
That's page 77, Volume 2. You found substantial evidence that the catalyst for the President's firing of Comey was Comey's, open quote, unwillingness to publicly state that the President was not personally under investigation.
I'm not going to delve more into the details of what happened. If it's in the report, then I'm supportive because it's already been reviewed and appropriately appears in the report.
And that's page 75, Volume 2.
Thank you.
Thank you. And in fact, the very next day, the President told the Russian foreign minister, open quote, "I just fired the head of the FBI. He was crazy, a real nut job. I faced great pressure because of Russia. That's taken off. I'm not under investigation," close quote. Is that correct?
That's what was written in the report, yes.
Time of the gentleman has expired.
Thank you, sir.
Gentleman from Virginia.
Thank you, Mr. Chairman. Mr. Mueller, we've heard a lot about what you're not going to talk about today. So let's talk about something that you should be able to talk about, the law itself, the underlying obstruction statute, and your creative legal analysis of the statutes in Volume 2, particularly your interpretation of 18 U.S.C. 1512C. Section 1512C is an obstruction of justice statute created as part of auditing and financial regulations for public companies. And as you write on page 164 of Volume 2, this provision was added as a floor amendment in the Senate and explained as closing a certain loophole with respect to document shredding. And to read the statute, whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under the statute or in prison not more than 20 years or both. Your analysis and application of the statute proposes to give Clause C2 a much broader interpretation than commonly used. First, your analysis proposes to read Clause C2 in isolation, reading it as a freestanding, all-encompassing provision prohibiting any act influencing a proceeding if done with an improper motive. And second, your analysis of the statute to apply this proposes to apply this sweeping prohibition to lawful acts taken by public officials exercising their discretionary powers if those acts influence a proceeding. So, Mr. Mueller, I'd ask you, in analyzing the obstruction, you state that you recognize that the Department of Justice and the courts have not definitively resolved these issues, correct?
Correct.
You'd agree that not everyone in the Justice Department agreed with your legal theory of the obstruction of justice statutes, correct?
I'm not going to be involved in the discussion on that at this juncture.
In fact, the Attorney General himself disagrees with your interpretation of the law, correct?
I leave that to the Attorney General to identify.
And you would agree that prosecutors sometimes incorrectly apply the law, correct?
I would have to agree with that one. Yes.
And members of your legal team, in fact, have had convictions overturned because they were based on an incorrect legal theory, correct?
I don't know to what you advert. We've all who spent time in the
one
trenches trying cases have not won every one of those cases.
Well, let me ask you about one in particular. One of your top prosecutors, Andrew Weissman, obtained a conviction against auditing firm Arthur Anderson, lower court, which was subsequently overturned in a unanimous Supreme Court decision that rejected the legal theory advanced by Weissman, correct?
Well, I'm not going to delve into that.
Let me read from that. Maybe it'll
May I
refresh
just
your memory.
finish? May I just finish
Yes.
my answer to say that I'm not going to get involved in a discussion on that. I will refer you to that citation that you gave me at the outset for the lengthy discussion on just what you're talking about, and to the extent that I have anything to say about it, it is what we've already put into the report on that
And
issue.
I am reading from your report when discussing this section, and I'll read from the decision of the Supreme Court unanimously reversing Mr. Weissman when he said, indeed, it's striking how little culpability the instructions required. For example, the jury was told that even if petitioner honestly and sincerely believed his conduct was lawful, the jury could convict. The instructions also diluted the meaning of corruptly such that it covered innocent conduct.
Let me just say, put in a word for...
Let me move on. I have limited time. Your report takes the broadest
excuse
possible reading of this provision and applying it to the president's official acts, and I'm concerned about the implications of your theory for over-criminalizing conduct by public officials and private citizens alike. So to emphasize how broad your theory of liability is, I want to ask you about a few examples. On October 11th, 2015, during the FBI investigation into Hillary Clinton's use of a private email server, President Obama said, "I don't think it posed a national security problem." And he later said, "I can tell you that this is not a situation in which America's national security was endangered." Assuming for a moment that his comments did influence the investigation, couldn't President Obama be charged under your interpretation with obstruction of justice?
Well, again, I'd refer you to the report, but let me say with Andrew Weissman, who is one of the more talented attorneys that we have and have on board.
Okay, well, I'll take that as
over a period of time, he has run a number of units.
I have very limited time. In August 2015, a very senior DOJ official called FBI Deputy Director Andrew McCabe, expressing concern that FBI agents were still openly pursuing the Clinton Foundation probe. The DOJ official was apparently very pissed off, quote unquote. McCabe questioned this official, asking, "Are you telling me I need to shut down a validly predicated investigation?" To which the official replied, "Of course not." This seems to be a clear example of somebody within the executive branch attempting to influence an FBI investigation. So under your theory, couldn't that person be charged with obstruction as long as a prosecutor could come up with a potentially corrupt corrupt motive?
I refer you to our lengthy dissertation on exactly those issues that appears in at the end of the report.
Mr. Mueller, I'd argue that it says above the Supreme Court, equal justice under law.
Time of the
not-
gentleman has expired.
Not stretched
Our
too
intent
thin.
was to conclude this hearing in 3 hours. Given the break, that would bring us to approximately 11:40. With Director Mueller's indulgence, we will be asking our remaining Democratic members to voluntarily limit their time below the 5 minutes so that we can complete our work as close